Chair, and thank you, General Holder, for joining us today. I appreciate the support you expressed earlier for the Smarter Sentencing Act. I've appreciated the opportunity to work with Senator Durbin on that and welcome the support of my colleagues as we try to move forward in a way that makes our law enforcement efforts more effective and makes sure that we don't continue to escalate our federal prison population at a rate of about tenfold as we have over the last 30 years. I wanted to talk to you first a little bit about metadata. Regardless of how you read Smith v. Maryland, and regardless of whether you think under Smith v. Maryland and its progeny, a constitutional case can be made for the collection of this data as it relates to American citizens, wouldn't you agree that at some point, when you amass an enormous volume of metadata on American citizens and you retain within the federal government the capacity to search that data, targeting potentially specific Americans, that gives the U.S. government a lot of power to peer into things that are, by their nature, very private?
Yeah, and it's one of the reasons why, in the interim, before we come up with whatever our proposals are going to be, the President has indicated that in querying that database now, we should only do so through use of judicial authorization. And so that ultimately may be something that we want to enshrine in the program, but that is what the President has asked us to do in the interim, unless there's an emergency situation.
Right. So you would make that tantamount to a warrant, in other words, and because right now what you have are internal operating procedures, internal regulations that can be changed, whereas if we put that in law, that would provide greater protection.
I think we want to try to work out what the mechanism might be so that we would afford the appropriate amount of protection while at the same time not having a negative impact on the operational abilities of people who need to potentially get access to that information on a pretty quick basis. But I think one thing we should understand is that although there might be billions of records in those metadata bases, I think the number for last year was in terms of the number of queries that were made of that database was about 300 or so.
I understand that. I understand that. And I think for purposes of this discussion, even if we were to assume that all of the men and women serving us within the NSA, even if they are acting in good faith and abiding by their own rules, at some point there is a very grave risk of abuse. And I don't know whether that might happen a day from now, a year from now, 10 years or 20 years from now. But you know, we've seen this movie before. We know how it ends, and we know that it's not pleasant. This will ultimately be abused unless we put in place some very significant restrictions. I heard you mention a few minutes ago in response to some of the questions asked by Senator Grassley that it's the President's preference to work with Congress, and that wherever possible he'd like to get Congress to agree with him to pass legislation that he would like. But, of course, the other side of that coin is something that the President referred to repeatedly last night in his State of the Union address, which is that if he can't get Congress to act, he'll go it alone. If Congress won't act the way he wants Congress to act, then he'll issue an executive order anytime he gets the chance. This brings to mind a concern that I've had as to whether or not sufficient analysis is being undertaken when these executive orders are issued. As you know, the Supreme Court has, since Youngstown Sheet Tube versus Sawyer and Justice Jackson's concurrence, and certainly since Dames and Moore versus Regan, when that Jackson concurrence was adopted by the majority of the court, it has tended to separate out executive orders into three categories. In category one, you have a situation where Congress acts pursuant to authorization by Congress. And that's where his authority to act with an executive order is at its strongest. Category two is where you have the President acting in the absence of either a congressional authorization or a congressional prohibition. Justice Jackson described this as sort of a twilight zone where it's a little unclear, it's a little murky. Category three is where you have the President taking measures that are incompatible with congressional command. And so I would ask, number one, is this analysis undertaken each time the President issues an executive order? And number two, Was that kind of analysis undertaken when the president, for example, announced on July 2nd of 2013 that he would not be enforcing the employer mandate of the Affordable Care Act throughout the duration of 2014, even though by law the employer mandate was set to take effect as of January 1st, 2014?
Before the president exercises the executive authority that he discussed last evening, and again, I want to preface that with, I think, the pretty clear indication from the president that he wants to work with Congress on behalf of the American people. In the absence of that kind of activity, as he's done with regard to raising of the minimum wage, he's used his executive authority to, well, will use the executive authority to raise the minimum wage for those who do business with the federal government. Those kinds of activities by the president are done after consultation with the Justice Department, and an analysis is done to make sure that the president is acting in an appropriate and a constitutional way. And those three categories that you talk about, that we all studied in law school from Justice Jackson, are among the things that obviously are part of the analysis. Where the president's authority is greatest, that twilight zone, and then where the president's authority is weakest.
So in which of those three categories would you put the president's decision to delay the enforcement of the employer mandate? Is that category 1, 2, or 3?
Yeah, I'll be honest with you, I have not seen, I don't remember looking at or haven't seen the analysis in some time, so I'm not sure where along the spectrum that would come.
How about the executive order that he proposed last night with regard to minimum wage? Would that be category 1, category 2, or category 3?
Well, again, without having delved into this to any great degree, that was...
But you're the Attorney General. I assume he consulted you.
Well, there have been consultations done with the Justice Department. From my perspective, I think that would put us in category 1, given the congressional involvement in the matter, the ability of the president to regulate things that involve the executive branch and how contracting is done. It seems to me that the president is probably at the height of his constitutional power in that regard, with regard to the one we're now discussing.
So you're saying there is a federal statute that authorizes him to issue the executive order regarding the minimum wage?
No, I think that there's a constitutional basis for it, and given what the president's responsibility is in running the executive branch, I think that there is an inherent power there for him to act in the way that he has.
And with regard to the employer mandate?
Again, as I said, I've not had a chance to look at it, for some time exactly what the analysis was there, and so I'm not sure that I would be able to put it in what category. But again, I would think that given that we're talking about a statute passed by Congress that delegates, devolves to the executive branch certain authorities, I would think that you're probably in category 1 there as well. But again, I've not looked at the analysis in some time.
Okay, I appreciate your candor on that, and I see my time's expired, but as I conclude, I'd just like to point out that this is very, very important, and it's one of the reasons why, as one of my colleagues suggested earlier, it could be very helpful for you to release legal analysis produced by the Office of Legal Counsel or whoever is advising the president on these issues. It's imperative within our constitutional system that we not allow too much authority to be accumulated in one person. And it's one of the reasons why we have a constitution, is to protect us against the excessive accumulation of power. And I think the president certainly owes it to the American people, and you owe it to the president as his Attorney General, to make sure that when he does act by executive order, that he do so clearly and clearly state the basis of his authority so that the American people can be aware of what's happening and on what basis he's claiming that authority. I look forward to hearing your explanation. Perhaps you can submit something to us in writing after this hearing about his basis for making some of these decisions, particularly with regard to the delay of the employer mandate. Thank you. Thank you, Madam Chair.
Let me just say that I have great respect for your legal analytical skills. You're clearly your father's son. But I also want to assure you and the American people that the president will not act in a way that is inconsistent with the way other presidents have acted in using their executive authority. He has made far less use of his executive power at this point in his administration than some of his predecessors have. And he will only do so, as I indicated previously, where he is unable to work with Congress to do things together. And that is the desire of the president, to work with Congress to deal with the issues that confront America.
General Holder, I respectfully but forcefully disagree with the assertion, if this is what you're saying, that because the number of executive orders issued by this president might be comparable to the number of executive orders issued by previous presidents, that means that he hasn't made more use of it than other presidents have. When you look at the quality, not just the quantity, but the quality, the nature of the executive orders that he has issued, he has usurped an extraordinary amount of authority within the executive branch. This is not precedented. And I point to the delay, the unilateral delay, lawless delay, in my opinion, of the employer mandate as an example of this. And so at a minimum, I think he owes us an explanation as to what his legal analysis was, particularly given the fact that it's difficult to imagine who's got standing to challenge this. And it's difficult to imagine who if acquiring standing to challenge this, could do so in a timely enough manner so as to avoid a mootness problem in the case. So it's all the more reason why it's important in this case. Thank you very much.
We have to separate then, I mean, with regard to the notion that there's a usurpation or that the president has acted in a lawless way. I think that is totally inconsistent with what the president has done and what his desires are to do.
Very good, Senator.